Welcome to Ground Rules, employment law over your coffee break. We are here in early 2026 talking about things to look for in 2026. What kind of trends do we anticipate? What kind of issues that started to bubble up in 2025 do we think are going to continue in 2026 or maybe get even more significant as the year rolls on? So I'm Pam Howland. I'm here with Jennifer Walrath and Doug Plass, and we're going to jump in and talk about some of these issues and give employers some ideas on what to look for and maybe how to handle these issues as they come up. So one issue that we wanted to talk about relates to some of the shifts and changes in the EEOC that we saw in 2025. And I think we can all agree it was a year where the EEOC started to look radically different than we had ever seen it look before. And as the year wrapped up, one thing that I wanted to mention was a post that we saw from the EEOC chair, Andrea Lucas. And this was on December 17th, 2025. And it said something to the effect of calling all white males who have been discriminated against based on race or sex. And it was basically inviting them to bring claims against their employers. And so I wanted to just talk about that because to me, that was really a shocking, jarring. I've just never seen anything like it. Like the government inviting white men to sue their employers for discrimination or harassment based possibly on gender. It's this concept of reverse discrimination that we have seen throughout 2025. And we have seen that as a consistent communication point from the EEOC that they're going to enforce Title VII equally without any regard, somewhat, I guess, to protected class status. So I wanted to ask Jen and Doug, what are your guys' thoughts related to that? And any tips or what do you think employers should be thinking about or doing with that?
So many thoughts went through
I
my
know,
head
I
all at the
bet.
same time. I think, and if you've seen us present, you've probably heard me say this before, the very idea that a white man could have a claim under Title VII, isn't something that didn't exist before, right? It was plausible, but often in a situation where perhaps a white man was the minority in a particular workplace, right? And then could say, other people who don't fit my characteristics are being treated differently and better than I was treated, and so I have a claim. What we're kind of seeing more now is a little different, right? And the post that Pam was mentioning came out around the same time that there was a news release by the EEOC about enforcing a subpoena in a court, I believe it was in Minnesota, but looking at this accounting firm. And, these allegations by a white male employee were along the lines of, I've worked here for a long time, and I have basically been hindered and discriminated against by DEI programs that have worked to support and give, opportunities to women and people of color. And that has hurt my chances and my advancement within the company. And the EEOC was sending out and trying to enforce a subpoena for additional records and information for potentially other people like this gentleman who might have experienced the same alleged discrimination. So, it really is just I think a different context than what we've seen before, right? Because for a long time, we had all these programs that, I think people would agree were in service of trying to raise up people who maybe historically had not had the same opportunities and kind of even the playing field. And now we are seeing the EEOC take the position that those same programs may now have disadvantaged, the previously advantaged, I guess you could say. So it definitely does look a little bit different. And, in terms of what that means for employers, For some employers, it's probably not going to have a lot of impact on your workplace, but for others, it may. If you have historically had programs like that in your workplace or have really focused on things like inclusion, diversity in the workforce.
Yeah, and I mean, I think it's important to always we keep hammering this home, but to understand that, this statements by the EOC chair are not changing the law in any way, right? Title VII is Title VII. And, anybody has a potential claim under Title VII. We're all members of protected classes. But what it's signaling is that from the EEOC's perspective, this is a problem, right? So they're saying now, from our perspective, we haven't seen a lot of that. So it's kind of hard to figure out exactly what to do with this, other than, recognizing that, when we're talking to employers, you now will have employees that are getting the message from the EEOC and maybe also kind of incorporating that this might be a problem. So they're seeing everyone's seeing actions through this lens now that was maybe just restricted to minority groups before, I guess. What do we do with that? Gosh, I don't know.
I think, be aware, knowledge is power, right? And if you get a claim or a complaint, someone comes to you under your anti-discrimination, anti-harassment policy from a white male, you better take it seriously. I mean, it could be a legit claim. We saw the Ames case from the United States Supreme Court that addressed reverse discrimination and said it's the same standard for everyone. Even people who would be perceived as being in a majority class have the same standard applied. So, you better take those things seriously and make sure your supervisors know and understand it, because it is a little different than how I, anyway, have always kind of traditionally viewed Title VII.
Yeah, and I think that if you are an employer who has or has had or has programs or initiatives, I don't know what you want to call them, right, to support sort of historically minority or marginalized groups, it's not to say that you would have to get rid of that, but maybe just reevaluate, see what you have in place. Is there any argument that you're favoring one group over the other or providing opportunities to one group that another group doesn't have? And maybe see if there's some way to provide additional opportunities or ensure that, the workforce as a whole has access to, kind of equal opportunity for advancement, training, all the things that help people succeed and progress as employees within your company or organization.
Yep.
And I think it's really kind of interesting to think about these developments in the context of another Supreme Court case that we've talked about, which is the Muldrow case, Muldrow v. City of St. Louis. And that case basically said it's a lot easier to bring claims than it was before. Any harm, some harm is what they said, qualifies as an adverse action under the discrimination laws. So if you have just kind of opened up the number of people who might likely bring claims and also expanded their ability to do so, gosh, we might see a lot more claims.
Mm-hmm. Yeah. And I was telling Jen and Doug earlier that one of our local clients said that they came back from the Christmas break and had more than a handful of new EEOC, Idaho Human Rights Commission type complaints in the door. So, I mean, it is feasible to think that claims and lawsuits could possibly be on the uptick here. So we've kind of talked a little bit about the reverse discrimination thing. And along those same lines, we also saw a communication from the EEOC in late 2025 talking about how it plans to prosecute national origin claims brought by Americans who think that they were disadvantaged by people from other countries. So that's another type of what I would think of as reverse discrimination type claim, not who we would typically maybe think of for protected class status, but something that the EEOC has been saying they are on the lookout for. So that's one area. Be on the lookout for these continued changes and shifts from the EEOC. What's coming next? We have no idea. It'll be interesting to see. Jennifer had a theory about what could be coming next, so I'm going to let her talk about that.
Yeah, I mean, this relates to the Pregnant Workers Fairness Act, which has now been in place for about almost coming up on 3 years. I think it'll be 3
That's
years
right.
in June. And the EEOC also had passed implementing regulations. So regulations that give additional detail and information about how to actually apply the law. Those were passed, I believe, in 2024. So they're a couple years old. And, if you've heard any of our trainings on the PWFA, it is as currently written and interpreted very, very broad, right? It covers not only someone who is currently pregnant, but even, pregnancy-related conditions that may predate or come after childbirth, right? So very wide spectrum of things that could potentially fall under the protections of the PWFA, which would be things then that an employer may have to provide accommodations to help that person continue working. And, my current theory is that in the next couple of years, it is possible that we could see changes or even a new set of regulations coming out of the EEOC. The chair, Andrea Lucas, has in the past, written I'll call it persuasive material explaining her view that as it is currently interpreted, the PWFA is too broad, covers too many things, and really should be focusing on pregnant women. So stay tuned. Now the commission only became back to fully formed status at the end of last year. So essentially, when they weren't at quorum, it limited the ability of the commission to act. They now have a quorum, so they can do a lot of things that they were not able to do last year. So we'll see what happens. I could be wrong, but I do think the PWFA is an area that the EEOC, they care about it. It is an enforcement priority. But the lingering question out there is just how broad do they think it should be? Will they do a rulemaking? And if they do, what will that look like?
Yeah. So thinking about the PWFA, that was on my list too of things to watch for in 2026 for a different reason than Jennifer's. Mine was as we continue to see how the PWFA gets applied in real life with real life scenarios. I think we're going to continue to see this complicated framework that employers are needing to work through when it comes to things like PWFA, ADA, and FMLA. Like, what happens when all three of those statutes are triggered? We're kind of calling that the triple threat. I think a lot of HR professionals out in the trenches are trying to understand this and work through it as these situations come up. And I think we're going to continue to see more now that law has been around a little bit. Like, how does that work when all three statutes are at play?
For what it's worth, even if the EEOC were to do some rulemaking that limited the scope of how it interprets the PWFA, I don't see the scope being limited so much that it would impact this triple threat concept. Like, I think it will stay in place and it will still almost assuredly cover women who are pregnant, which is the time that it would be most likely to be dealing with all three statutes at one time, the ADA, PWFA, and FMLA.
Yeah. Maybe like 15 years ago, there was this whole concept of how do you deal with the ADA, the FMLA, and workers' comp. People referred to it as the Bermuda Triangle because it was really difficult to figure out, like, what do you do when all three of those statutes are implicated? And I feel like now this kind of creates another Bermuda Triangle Part 2 scenario. And I think, as I've kind of started to think through it. And I'll have to say, we haven't had really clients calling yet with the scenario where all three are implicated, but I think it's coming. And I guess in my mind, what I finally realized is the best course of action, I think, just like it was 15 years ago with those other three statutes, is probably just to make sure you're analyzing each statute separately and that you're providing the maximum relief available under all three, rather. So I think that's where I've landed, and that's what we're going to try to continue to give guidance on that. We have a training we're doing on March 31st where we're going to dig in and go through some of those difficult triple threat scenarios, but stay tuned for that because I think that one's going to continue to evolve in 2026. So what else? Like one thing we had on our list, which you've heard us talk a little bit about on the podcast, is the difficulty that employers have when they have some type of off-duty social media post impacting the workplace. It could be harassing. Maybe if it's harassing, that's an easier call for an employer. They know that if it's harassing, they probably need to do something under their anti-harassment policy. But what if it's not quite harassing, but it's more like political type comments that are creating conflict in the workplace? What if it's something more like a lack of professionalism or disrespect, something maybe that falls short of harassment? What do you do with these off-duty social media posts that are on private accounts? I think that's an issue that we're going to continue to see. In the fall, we had the Charlie Kirk incident, which I think really created a lot of social media content that employers were worried about. And we were getting calls from concerned clients going, okay, what do you do when you've got one employee demanding that another employee take down an offensive post when all this is happening after hours on private accounts? So, Doug, Jen, what do you guys think about that one?
Yeah, well, I mean, I think this is one of those where it's really important to have good policies,
Yeah.
right? Because, your policies might say, don't use your work credentials to post anything on social media or don't do it at work. Well, that's not going to cover the situation that Pam was just talking about. So you really need to be thinking about what your policies are and whether or not they're dealing with kind of out of work conduct that makes its way into the workplace. And it's not easy, I mean, it's going to require a little bit of thought to figure out exactly what you want to do there. But it's really important that you actually go through that exercise and think about it.
Yeah, I mean, I was just sitting here thinking, one of the recent cases out of the Ninth Circuit, the thing that has really stuck with me about it is this idea that even though social media is outside the workplace, because everyone has a phone and it's accessible on the phone, that as long as someone has the phone in their hand and has access to their phone at work, they have constant, easy access to the social media. And that in some circumstances, that might just mean that social media is kind of always in the workplace, which is sort of this mind-boggling concept, right? Because on the other hand, as an employer, you don't want to be responsible for basically policing your employees' social media accounts. So finding that fine line, right? I mean, I think the line kind of is fine because you don't want to take responsibility for policing, but to the extent that it comes into the workplace, you do have to figure out a way to deal with it. And probably for different workplaces, that is going to look a little different jobs, different roles. So Doug's right, kind of thinking through it in advance. How have you seen it coming up in your workplace? Have you seen it coming up? How do you think it might come up? Maybe thinking through some scenarios and how, you would like to see them play out. Where would you have to do something to be compliant with the law? And then, kind of prepare policies accordingly. And it may be something where it's going to take a couple of, iterations to get it right, where you might have to go back and look at that policy every 6 months, every year, just to make sure that it's working the way that you want it to work, because this really is one of those areas where I think it also is going to keep changing and evolving over time as technology evolves, different platforms, types of social media become available, etc.
Yeah. And that Okanowski case that Jennifer's thinking of, you guys impressed to remember the name?
I am.
I was like, it just popped into my head. It has some really interesting takeaways. And one thing that stands out in my mind about that case, which involved a female employee who felt like she was being targeted on a social media account by a male coworker. One thing is the court said it's not adequate just to tell the employee who has the issue with the post to just quit following it or just quit looking. You have the power to just ignore it. I mean, that's clearly not going to be enough in most circumstances. And the other is if that one is a big one tracking a theme, which is also on our list, which is if somebody brings a complaint, you better look into it adequately. Because in that one, this female came forward to HR repeatedly and said, I'm worried about my safety. I'm being retaliated against. It's impacting my ability to work, and HR did not adequately investigate it or handle it. And in fact, there were a lot of inappropriate comments made by HR and other leadership, like, oh, come on, it's kind of funny. Things like that are never going to be okay when it's in front of a court. Courts don't have a lot of humor, FYI. So, your leaders need to be trained. Investigations, I think now in 2026, having them done right, timely, by the right, unbiased, neutral people. That's only going to be more and more important. And we did see an uptick in 2025 of claims brought by the EEOC, where the EEOC made comments of the employer did not adequately investigate that. And there is an obligation to do that. So that's another important takeaway.
Yeah, that's something that I'm hopeful will be a good trend for 2026 is more employers are recognizing the need for those.
Yeah.
Because it really does seem like they are.
Yeah.
We've had more discussions about, okay, what should we do about this? Should we bring in somebody? And yes, usually.
Right. Yep. What else? Let's talk a little bit. How about AI in the workplace? That's another trend that we can all agree probably not going away, right? It's only going to change and morph into other issues, other concerns. AI impacting employment law issues for employers. You guys have any thoughts on that one?
Yeah, I mean, I have a lot of thoughts about AI. But I mean, one of them is, and one thing that we've seen is, kind of employees using AI like it's a, I guess, very knowledgeable pseudo lawyer or something, right? Like kind of bouncing ideas about something that they feel like they've been treated unfairly about off of AI. And then we see that snowball into, eventually into a claim or a lawsuit. I think there's going to be a lot more of that.
Yeah. Yeah.
That's definitely one thing. And as Doug was talking, I mean, there are a lot of just different ways I think that employers are going to see AI continue to impact the workplace. Probably people listening could think of things that we're not even going to be listing off or talking about, but, kind of new in different ways that people could say they're being subject to a hostile work environment or being harassed by somebody, right? Somebody creates something and puts it on social media or sends it by email or text or instant messaging platform within the company. Then also the aspect of just protecting information, right? If you're an employer, do you want to let your employees use generative AI? If you do, what kinds of tasks can they use it for? Is it an open system, a closed system, right? There's just so many things to think about. Having a policy is a good idea for your AI, right? Like, what can they use? What can't they use? What information can be put out into the AI? world.
Mhm.
I realize I'm not using very technical terms. And we've kind of been doing the same thing here. To some extent, you have to kind of understand the technology in order to figure out what you are willing to let it be used for or not let it be used for. And so, for some people that's going to be not a problem. They're up on the technology, but I think for other employers it's going to be a bit of a learning curve.
Yeah. I was even thinking about, you've heard us talk about AI in the hiring process. We've already seen some cases related to that. I'm seeing more and more about AI generated performance reviews and potential problems with that. I think who knows what else we'll see this year, but definitely all of those things need a second look to make sure that, if somebody's got an accommodation, that's not giving them a poor rating for performance or disqualifying them as a candidate for a position. But I think we'll just keep seeing more and more. And Jennifer's comments about an AI policy, we spent a little bit of time earlier this week in our conference room thinking through how do we update our anti-harassment policy, anti-discrimination policy, thinking about all of the new ways there are out there that someone could harass someone related to new technology, related to AI. I mean, it is a good time to pull out your policy. Is it dated? Do you need to think through scenarios that went down in 2025 that you want to make sure don't happen again in 2026, and whether or not your policy language was what you needed or not?
And I was just thinking too, one of our attorneys who's not sitting here in our podcast room right now, but Megan was talking about the story where an employer was using Zoom to do an interview.
That was a good story.
And, Zoom now sometimes has the automatic, it'll make the transcription of the discussion that is had during the meeting. And while at the end of the interview, the interviewee signed off, but the interviewers stayed on the Zoom and kept talking, and the transcript kept running. And at the end of the call, it sent it to all participants, including the interviewee. Now, in that case, as far as the story goes, nothing was, troublesome or problematic content-wise in terms of what the interviewee received. But something to keep in mind, right? I think for some of us, you may not even realize that that has now been integrated into an application that you've used for years. Do you want that on? Do you want it off? Do you know how to turn it off? Right? So maybe even just going through some of your, you know, things you use in your workplace, right? Even your Microsoft cataloging. Which of those things have an AI component? How does that AI component work? And do we want to allow that component, not allow that component, or let's educate people in the workforce about it and how it works to avoid something like that, in that case, apparently ended up being not a bad ending, but certainly could have been problematic for a number of
Disastrous.
reasons.
Yeah. Yep. Yeah. Would you want all your verbal comments after every interview candidate transcribed and sent around to everyone? Yikes. Probably not. So, okay. Lots to look for with AI. Last topic that we were going to touch on just briefly: changing economic conditions. Do we need to be watching, for economic conditions that lend themselves to layoffs, reductions in force? Just a reminder that if we start to see more of that, we know we have escalating healthcare costs, we have tariffs, we're hearing more and more employers struggling just to stay profitable in light of factors beyond their control. So, those things all have a tendency to lend themselves to an increase in employment law claims. More important than ever to document performance issues, right? If you're going to do a layoff, and if you're going to use performance as one of the factors you're relying on, it's better to have it documented, right? And always be thinking about just the legitimate, non-discriminatory reason.
Yeah, and I'll throw out there too, for larger employers, maybe not even that large, for some employers, you might even have to think about additional compliance issues like the WARN Act or Older Worker Benefits Protection Act. Just things that, for example, if you're laying off a certain percentage of the Sorry, I need to say that again. If a certain percentage of the group you're laying off are 40 plus years of age, for example, there are, certain requirements for how you do the layoff.
Yeah, and notice.
And notice that has to be provided. So, we don't need to dig into all those today, but just be aware that if you are doing a large scale layoff of some kind, maybe even not all that large of a scale, even, 5 people, for example, like one department or something like that, it's worth at least looking to see if you're triggering any additional compliance requirements.
Yep. No shortage of issues to be on the lookout for in 2026. To that end, we've got some exciting resources for you guys. We've been brainstorming, like, what could we do that would help employers stay on top of these things? We have our trainings mapped out for 2026. You can find those trainings if you go to updates.idemploymentlawyers.com/2026 training bundle. We have the trainings mapped out, and for a period of time through January, we have training bundles where if you get all the trainings, it'll save you a little money. So that's one thing to be on the lookout for. We have gotten a lot of input on our Law for Leaders program, and we're kind of reconfiguring some of those offerings, how we're going to make the recorded content, what's going to be included in that. We're getting ready to, roll that out in early 2026. And then another thing we're looking at is this is the best one. This is really exciting. A lot of HR people say, come on, employment law is kind of boring. Like, how do you make this exciting? How do you make it interactive? How do you get leaders talking about it? How do you get them engaged without just inundating them with too much info or boring them to death, right? So we totally disagree that employment law is boring. It's not. But we came up with the best interactive tool. It's a game, and it's coming soon. So watch for that. It's a card game. It's really cool. We're getting ready to hopefully have the prototype done. I'm hoping by March is what I'm hoping. So we know we'll be at the HRATB conference in April. It would be so cool if we had those ready to go in April. It's on its way, and you guys are going to love this. I promise you're going to love this. We're talking about writing our second book. That would be in later 2026 for sure. But we are thinking about leaders and employers and how we're going to help you. Because as you can tell by these topics, I just think it's going to continue to be more and more complex with more and more changing and shifting issues. So we're on it. We got you. Stay tuned. So that's it for today on Ground Rules. We'll see you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.